Okay, we are live.
Hello. Morning, Ms. Good. Good morning, everyone. This is our last meeting of the Fairness Subcommittee. I hope everyone is well and enjoying your Tuesday, beginning of Tuesday. Let me see, Mr. Ewart, you are going to call the roll. Excuse me, the meeting, it's 10:03, so we're beginning our meeting. Mr. Ewart, will you call the roll?
Sure. Michelle Anderson. Don't see. Ray Buenaventura.
Present.
Ruben Duran.
Present.
Sarah Good.
Here.
Shalon Joseph. Jerry Larkin. Melanie Lawrence.
Here.
Ed Lear. Judge McGill. I see you.
Sorry, I forgot I was muted.
Okay.
Morning, present.
Steve Moab.
Here.
Ellen Pansky.
Here.
Sean Salig.
Here.
Martin Winfield. And Chair Buffington. We have a quorum.
Thank you. Okay, now I believe it's time for me to call for public comment. Ms. Ewart, did we get any notification that someone would be joining us this morning for public comment?
We didn't get any prior notification. There is one attendee in the attendee pool. So if they would like to make public comment, if they could raise their hand now. And I don't see the hand raised, so I don't believe that there is any public comment.
Okay, thank you. Okay, Ms. Ewart, am I turning it back over to you to go over our agenda for today?
Yes, thank you, Chair Buffington. Lisa, if you could share the second slide. Prior to today's meeting, I just want to go over the timeline. Those of you that have been on effectiveness or some of our working groups, you've been able to see this timeline, but I wanted to give it to the Fairness Subcommittee. In September, we've scheduled a meeting for the full ad hoc commission on September 17th, I believe, and that is where we are going to bring the Effective Subcommittee and the Fairness Subcommittee back together to report on the actions that they've taken and the working groups that they have formed, and then also potentially form some more working groups to come up with recommendations. Those working groups are scheduled to work the last part of this year. So you see September through January of 2022. They are going to detail those recommendations, get the findings and come back to the full ad hoc commission in February through April. I don't exactly have specific dates, but it will probably take a couple of ad hoc commission meetings to get the working groups recommendations and vet them and discuss them. And then the full commission in late May or early June will adopt the recommendations from the working groups and then present the full report to the Board of Trustees, because the deadline to get the report to the Board of Trustees is the end of June. So this is just to tell you that the subcommittees, this will be the last subcommittee, and then the working groups will be doing the detailed recommendations, and then it makes sense to bring it back to the full ad hoc commission for the recommendations. So that is the timeline. And then the next slide is just about our agenda today. We have several different topics. The first is communication with complaining witnesses. The second is communication with respondents who received dismissed complaints. And this topic is bringing back from something that we discussed further, but we're kind of closing the loop on this issue and seeing if there are any recommendations that need to be done. Attorneys' costs and fees is another one where we're closing the loop. We've presented on this before, but there seems to be some interest, so there might be an interest in developing a working group. Attorney representation, again, is something that we're bringing back to the subcommittee for further discussion. And then the last part of the agenda is summary of next steps. And that's where we, since this is the last meeting of this subcommittee, we will bring back all the topics that we've discussed and just make sure that the whole commission understands the roadmap ahead, whether or not working groups need to be formed, and what exactly the next steps are. So that is our agenda for today. we can proceed to the first topic.
Hi, good morning, everybody. My name is Kelly Gerner. I am a senior trial counsel with OCTC, and I'm here to walk us through these first couple of topics. Our first one is communication with complaining witnesses during intake. During the intake process, that's when we do our initial legal review of complaints filed to OCTC by members of the public. Let's go ahead and move to the next slide, please. So kind of when we are at the intake phase, so this is pre-investigation, our purpose of communication with complaining witnesses at this early stage is really mostly to flesh out their complaints more. A lot of times we do need to obtain further information to substantiate their complaints. A common thing that we would request from a CW at this stage is, for example, a legal services agreement, something that would show what their connection to the attorney was, whether they were that person's client or whether the attorney is an opposing party. We might also request information about the underlying case, right? So that might be a case number, so that way we can look it up independently on a Superior Court website or something similar. So that's kind of our primary purpose of communication. If we do go ahead and close the complaint, of course, we'll communicate with the complaining witness to explain why we close the complaint, and we do give them a legal analysis explaining why the information they provided to us either failed to meet our threshold for further investigation, or why we were closing for another reason, such as, you know, the conduct that they complained of might not have risen to the level of attorney discipline. Finally, we do provide them further direction if they're dissatisfied with our conclusions. That could look like referring to our complaint review unit. We give them information, if applicable, about reaching out to a lawyer referral service or to their local county bar for fee arbitration as well. So those are some of those further steps that we might give to a complaining witness. So we can move on to the next slide. There's 4 types of letters that we would send out to our complaining witnesses at the intake level. The first one is what we colloquially refer to as the CCW letter, which just stands for Contact Complaining Witness. This is the kind of thing that I was alluding to previously, where we would ask for a fee agreement, proof of payment to the attorney, anything that would sort of further substantiate their complaint or give us that information that we need to understand the allegations. We would also send out a similar type of letter if the complainant was complaining perhaps on behalf of the attorney's client, but was not the attorney's client. So to prevent an attorney-client privilege problem down the line, we want to get the attorney's client on board with the complaint if they wish to join it at that intake phase. So in those cases, a typical thing you might see here is if someone is experiencing incarceration, their parent or spouse might file a complaint against their attorney. We would then ask and say, well, no, actually the person who is incarcerated needs to complain and they need to join us to preserve attorney-client privilege. So we would then go ahead and ask for ours actual client to join that complaint. On our next slide, I'll go into the other 2 kinds of letters that we traditionally send out to complaining witnesses at the intake phase. So that would be, oh yes, our next slide, please. I think that's the same. Thank you. So our closing letter, right, and this is where, as I said before, we explain our reason for closing. We do provide information about next steps or other things they can potentially do. And one other thing that we'll do is we will invite them to provide additional information if they disagree with our conclusions, right? So if we make some sort of finding and they say that's actually wrong, you have the facts wrong, we do kind of give them a second bite at the apple, so that way they can come in, provide more information to us and give us a chance to revise our decision. And if none of that is satisfactory for them, we do go ahead and refer them to our complaint review unit with OGC. Finally, in the instances where the CWs have provided additional information, but we found that that was insufficient to reopen and refer the case to further investigation, we would send what's known as a stay closed letter in intake, where we just explain to them, thank you for the additional information. Unfortunately, that's not enough for us to reopen the case, and the matter will be staying closed. So that sort of is like the umbrella of the kinds of communication that we have with CWs at that intake pre-investigation level. And I think if we move along, we can talk about the types of things that, well, I should ask actually, does anyone have any questions first? I can kind of give more information about any one of those. Okay, so seeing none, I will move ahead to the kinds of communication that we have with respondents when their complaints are dismissed. Thanks, Lisa.
Before we get started, can I just take a moment to tee up this topic?
Sure, please do.
So early in one of our early meetings, this topic came up kind of spontaneously, and I believe someone pointed out, asked to clarify, do we contact respondents whose complaints were dismissed without action? Their answer was no. And then the question was raised, this is a fairness issue. And so the State Bar, as you know, we did kind of like an informal survey of other jurisdictions. And I shared this slide earlier on in the process, but I believe it got lost in one of those marathon meetings we had. So I just want to review that. So when 13 jurisdictions shared that they did notify respondents when their complaints were closed with no action taken. And I include like 2 quotes here because some of our partners did share out like the reasoning behind different actions that we asked for. So here's some quotes. One is from Florida and one is from Illinois with regards to like why they do that. So Florida says, if we close it at intake without requesting response, we send the complaint to the lawyer in hopes that the lawyer will improve his practice and avoid future issues. And Illinois, so we almost always send copies of the complaints that we close to lawyers. We sometimes note concerns and potentially applicable rules and offer, quote, friendly advice in the cover letter forwarding the dismissed complaint. So I just wanted to like tee up, like I said, this topic and just remind us why we're reviewing it. Okay, go ahead, Kelly.
Thanks, Lisa. I think that's really valuable context for this discussion. We do not have that level of communication with respondents, and there's a few reasons for that, which I'll kind of go through. So starting with the kind of communication that we have with respondents at the intake level, it's virtually zero. I think in this slide, I put that communication is limited. Limited means very, very limited. I mean, there's pretty much none. So the type of communication that we would have with respondents at that intake level, it would be, it's limited truly to the kinds of things where we think that we can resolve a potential complaint at the intake level. So that would be a situation where we might send out a directional level, such as directing the attorney to return the client file, such as directing the attorney to reach out and communicate with the client, or directing the attorney to communicate or settle a lien with a third-party lien holder. Those are like the very, very limited types of communication that we do have with respondents at the intake level. And some of the reason for that is because out of the many complaints that we receive over the course of the year, approximately 60% of those do close at the intake level. So we have a massive volume of complaints that are closing with no action taken at the intake level. There's some interesting implications of communicating with the respondents. The first one being a resources issue, finding the time and the manpower to, even to do what Illinois and Florida are saying, where they're saying, oh, we just kind of forward the complaint along and give them a friendly heads up about what's happening, or here's a citation to a rule or something like this. At the volume of complaints we receive and with the manpower we currently have, that would be extremely difficult. And some other considerations there that complaints that are closed for lack of merit don't necessarily give the respondents useful information in every case, right? If it's something where the CW has complained about something that we found to lack credibility, for example, letting the attorney know about that doesn't necessarily give them information that would maybe lead them to change their practices or anything like that. The other problem is there could potentially be harm in terms of the attorney's relationship with their clients and opposing parties. There could even be a chilling effect once complaints are filed, if it gets back around to the attorney that this complaint was filed with the state bar. So we can move on to the next slide, and I'll talk about the kind of communication that we do after intake, once a matter has gone forward to investigation, but OCTC still makes the determination that the matter should be closed without any discipline. And in this case, there is a little bit more communication, as in a letter is at least sent to the respondent, but even this communication is quite limited. These letters tend to be typically quite brief with little detail about the investigation or the reasons for closure. There may be a simple direction similar to what we would see at the intake level, such as returning a client file or reaching out to communicate promptly with the client. But ultimately what is sent once the matter has been investigated, the determination has been made not to seek discipline against the attorney. It's a brief letter stating the investigation concluded, the case is now closed without prejudice. And that's pretty much all the attorneys have to go on. There is always contact information for the investigator or the legal advisor. So the attorneys do have an opportunity to call or reach out in some other way to get more information. But from my personal experience, that's pretty rare. Generally speaking, when respondents learn that their matter has been closed, they're happy about it and they just sort of go on their merry way. So again, that's sort of my summary. And if anyone has any questions about that for me or Melanie or Steve, I'm happy to entertain.
Well, if I could just add, Kelly, on the investigation letters. So it is pretty summary in terms of the actual closure, but keep in mind that we've had contact, more substantive contact with the respondent during the investigation. We are required by rule to advise them of the complaint, the contents of the complaint, and request a response. So we will have at least gone through that process before they get a closing letter.
Ms. Lawrence, and is this done via email, mail? Like, how is the correspondence with the respondent during this time, the investigation phase?
Yeah, so in most instances, first of all, it is in writing. The rule requires it to be in writing, but in most instances, we upload it to the respondent's profile page, and then we send them an email letting them know that there's an important communication from the state bar that's been uploaded to their profile page so that they can access their profile page and view the correspondence. If we're not getting a response from the respondent in that manner, we may also send a letter via U.S. Postal Service as well.
Thank you. Mr. Duran?
Thank you, Madam Chair. Thank you, Ms. Gerner, for the information. Very useful and intriguing. I wanted to ask a question, something along the lines of comparing apples to apples, and I'm not even sure if it's possible, given sort of the size of our regulatory audience. But the two examples that Ms. Chavez put up, Illinois and Florida, who do send letters at the close of intake with no merit, they're pretty big bars, I'm assuming. And so do we have a sense of how many complaints those bars get annually as compared to California? And also, second part of that question is, there's my dog howling, I apologize. The second part of that question is, what are the respective sizes of their staffs, if you know?
Well, I would defer to Jerry just because he's intimately familiar with Illinois, at least. And I think he probably has some idea about Florida. But
thanks, Steve. I am familiar with both, obviously. Illinois is at a shrinking number of grievances over the last period of time. When we adopted these approaches that Ruben is talking about, we probably had 6,000 to 7,000 inbound grievances. Our staff back then probably included 5 intake lawyers with support staff and about 25 litigation counsel. But what we're talking about mostly, and I was interested in Kelly's presentation, is, and I missed the first part of it. I had a glitch in getting on due to my fault, so mea culpa. But it's, we went to a whole different view of engaging the lawyer. I prefer not to use the word respondent, but it is a very common term across the country. And engaging the complainant, figuring as a regulator that would work, could work better, and not just on letter. It's not easy because with volume, everyone has difficulty keeping up with it if you're going to be proactive. But in Florida had a larger number. They have an intake division, which is maybe a little bigger, and they do a lot more telephone work than we do with complainants. So we're trying to move in that direction. I believe they do more, but I'm not sure of this, communication outside of written communication with lawyers. I'm not sure of that. The other organization I think might be instructive would be Colorado. But you know, I think it's fundamental. There's this, it's how any of us as regulator want to deal with. I think it's the best way to deal with the lawyers whom we regulate and the public whom we all serve. And so we've come at it a little differently. And maybe part of it is we learned a little bit from the old days of California, and you've made a choice for whatever business purposes you have to and volume is a big part of it, to serve public and lawyers through written communication. Though I think it's not an all or nothing at all. I believe Florida has about 10,000 grievances a year. Last I checked. Our staffs are, ours is smaller now, or we're shrinking our staff intentionally. Our budget is $18 million. So our budget is a speck compared to yours. Florida's, I think, would be maybe a little more, but it's not a question of, we have resources to allocate more resources if we need them. Our caseload doesn't demand it right now. So put us in, our lane is different. I'm not trying to suggest how California should run its business, and lots of different states do it differently. We just have chosen in California, and Florida has chosen to have different touches with the public and with lawyers. In addition to the writings. Writings are common everywhere. Steve, is that close enough? That answered part of your question?
It certainly answered mine. I don't know if I assume Ruben will answer whether it answered his.
See my hand go up? Madam Chair, if I may, just to underscore what Jerry just said, and I think I understood him correctly. And each of the numbers that he quoted were annual numbers for those various jurisdictions. And if I'm not mistaken, California receives more than each of those numbers in a month here. So that's just to, I prefaced my comments with apples to apples, and I really think we're talking about, peas to apples, which is a really bad simile. So I apologize.
I'm not sure I'd go there, but there's a scale, right, Ruben?
Yeah.
Your budget is multiples of ours. Your staffing is many multiples of ours. And I think it's a question of, I'd like to think it's a question of just regulatory philosophy, at least in part. And that's a fair question that each agency, each state must answer for itself. And I know that you're under tremendous backlog pressure. And a lot of what I perceive is that the economy of dealing in writing is critical to addressing backlog. And you may have departed from some of the things we're doing now, but it's just a I mean, I'm guessing our staffing and our resources are somewhat proportional to the lawyer population and the workload.
Thank you, Mr. Arkin. Ms. Lawrence, I see your hand is raised.
Yeah, I just wanted to add sort of a little bit of historical perspective, and I think we might have talked about it at one point, but there was a time in our office for many years, actually, where we did a lot more communicating with complaining witnesses, at least. And we had a whole staff of folks who basically manned a hotline, if you will. And there was a lot of, they would be on the phone for 8 hours a day. Sometimes those folks who were calling didn't necessarily file complaints. They just needed more information, sometimes referrals to other sources. As often happens, there was a requirement of our office to engage in a workforce planning study. And so we did that. Part of the recommendations were that we eliminate that function in our office. Not that it be eliminated entirely, but that it be eliminated from our office. So it moved to another part of the bar, and they do much more limited service for complaining witnesses and others who are contacting the bar. So we did do a lot more of that. We just don't do it now.
Thank you, Ms. Lawrence. Any other hands or questions or comments?
And just the number of complaints we get a year, Melanie or Steve, I thought it's not close to 10,000 a month. It's more 16, 17,000 a year or something.
Oh, upwards of 18,000.
18,000 a year? Okay,
yeah.
so like double, but a year, okay.
You're clarifying that.
Yeah, no, thank you. I appreciate that.
Looks like Sean has his hand up.
Mr. Lee?
Yes, thank you. So, I just wanted to offer one thought about this idea of telling respondent lawyers when a complaint has been closed summarily. There's something there's an unintended consequence of changing this practice that we should consider, which is if we notify lawyers of these closed complaints, then they are likely going to be required to disclose them in response to certain inquiries such as from insurers and employment applications, things like that. So I think that we should take that into some careful consideration, because if we're concerned about fairness and we know, for example, that African-American male attorneys receive more complaints than other attorneys, it could be quite counterproductive actually to start sending people letters like you've gotten 10 complaints this year, because then they have to report that to various folks. So, and then it all has to be explained and so on and so forth. So, so anyway, I just think that's a serious consequence of a change in this policy that we need to consider.
Thank you, Mr. Salig. As people were making comments, I was just thinking, is it possible that we could possibly have like a pilot program to see how effective this practice, if implemented, will be, as opposed to just saying, hey, this is our recommendation, hope that the Board of Trustees will adopt it, and then the policy changes and we have some unintended consequences we have to deal with kind of down the pipeline. Just a thought. Okay, I guess I don't see any more hands.
Oh, I see Ellen
Okay.
has her hand up and Sarah.
Thank you, Mr.
Sure.
That's good.
I just wanted to echo Mr. Seleg's comments. Certainly within the context of private law firms, there would be a pretty heavy disclosure obligation to attorneys to raise that with their malpractice insurer within the law firm as part of the annual process. And then also with lateral movement of lawyers from one law firm to the other. It's very routine to ask questions that would require disclosure of this information. So just wanted to say, I thought Mr. Seleg's point was excellent and in fact, very, very real within the private practice sector. Thanks.
And Ellen has her hand up.
Thank you. From the respondent's point of view, the issue is tied to the issue of confidentiality of complaints. In some jurisdictions, as I understand it, whether a lawyer has received a complaint, regardless at the stage at which it's closed, is public information. So what I always tell my clients is it's actually a beneficial policy, because if the complaint is groundless, it doesn't serve the lawyer's purpose or the public's interest in having a public record of complaints that never had any merit. So it's kind of a quid pro quo. If the complaint is treated as confidential and the public is not entitled to know, the flip side of that is the complaint is confidential unless and until the state bar determines that there's at least some probable cause to notify the lawyer and require an explanation. So my personal view is it's better all around to give the complainant anonymity. So if they're concerned about any kind of, retribution or negative consequence, they can be assured that they can make a complaint without being concerned that there's going to be an adverse consequence, even if the complaint has no merit. I also would say that I thought that there was a procedure where a respondent upon request would be provided a list of complaints, even if they were closed without action. I don't know if there's a good cause showing, but I do know, for example, if a lawyer is applying for admission in another jurisdiction, the state bar will provide a list of all complaints received with an explanation of their disposition. And at that point, because the lawyer is going to be called upon to explain to the other jurisdiction what these complaints were about, that information then is also provided to the lawyer. I'm just not clear whether there's any restriction on that or how that works. And I'd like to know, is there a protocol on that?
Thank you, Ms. Mansky. Who can answer that question?
Looks like Kelly has her hand up.
Thank you.
I can answer Ms. Pansky's question. So with respect to, attorneys can reach out to OCTC at any time to get sort of a copy of their complaint history. Generally speaking, as you mentioned, Ms. Pansky, that happens in the context of applying for membership with another state bar. It can also happen if someone is going up for a judgeship or something similar. There are those instances where folks do need to have a complete complaint history, and that is something that we'll provide to them upon request, as long as we've verified that it is the attorney who's asking. So we're making sure that we're not running into confidentiality problems. And that's something we do fairly frequently. Another thing I wanted to sort of throw in the mix in terms of the unintentional consequences, one of the things I see a lot on the ground in the intake unit is there are certain practice areas where people will receive many, many more complaints than folks in other practice areas. So one thing that comes to mind are public defenders or criminal defense attorneys. They receive a disproportionate number of complaints as compared to other practitioners. And one thing that I could see as a potential unintended consequence of sending out sort of a, hey, you have a client who complained against you letter anytime that happens, is that these folks would then start to disregard communications from OCTC or from the state bar. They would get them so frequently, especially if you're a public defender doing a high volume practice, you would get these kinds of letters several times a year. And then when a truly important one came out, when it is a situation where, you do need to respond and take it very seriously because we've initiated an investigation, that might be something that gets backburnered and not treated with the amount of attention and cooperation that we would expect. So just another thought there.
Thank you, Ms. Garner. Are we, any other questions or comments? And are you done presenting, or we?
Yeah, we're kind of done presenting on this subject, but I would like to kind of close the loop because we're examining this subject because there is potential preventative or some sort of benefit that other states have derived from notifying the attorneys of this process. That's why we're examining it. We've now heard, things that could be problematic if the subcommittee wanted to do this. So I'm just curious, is this an area where the subcommittee would like to explore further? Do they have enough information now? Are there recommendations so that we could form a working group on this if we wanted to, or we could just, like you said, talk about a pilot program. And this is where this subcommittee is separate from the bar. So this subcommittee can make these recommendations, knowing that the bar has problems with implementation because of workload and its costs and things, but this subcommittee, needs to make the recommendations with all the information, but they can make recommendations that could be problematic to implement, but that's up to the bar to kind of determine implementation or the legislature to fund the implementation. So I just wanted to get the subcommittee's take on where we should go with this, kind of how's everybody feeling about this? Does the benefit of notifying them outweigh the possible conflicts and disclosure problems?
Yeah, I don't think we know that until we have some more information on impact on our resources. I would suggest that we just conduct further study benefits as it relates to costs, impact on resources, but that's just my opinion.
Ray has his hand up.
Yes.
Buenaventura, yes.
Yes, thank you, Madam Chair. I guess I had a question. I see the arguments really for both sides, and I thought they were very good. And I'm bringing this up because I'm not sure if this is part of the discussion or is this going to be happening later. But my concern is, so what happens after the complaint? Meaning, what effect or how much weight are the accumulation of complaints given to future decisions to discipline an attorney? So I guess my concern is if there is, you're building a bank of complaints and they're not being, let's say, acted upon because the bar found them not credible or not actionable. So my concern is if an attorney starts to get all these complaints, which they were not sustained or not actionable, what effect, if any, are you going to use that against the attorney in the future? And the sort of lack of due process in trying to, if there was a need to remedy that and they're not able to because they didn't know about it. So I think I'm comfortable if the answer to that question is, it's really not probative at all. It's not, going to be weighted in any way. But if there's an accumulation and the attorney doesn't know about it, but then later on gets subsequently dinged because of it, then we got, I think, an issue. So that's it. Thank you.
Right. Ms. Lawrence, I see your hand is raised.
Sure, just to that point that was made, just some information. So the fact that there are complaints and that they were closed, especially at the intake level, is not determinative of whether a case moves forward to investigation or whether discipline is imposed. That's not part of the consideration. Now, I know that there are concerns out there and that it's something that has been discussed in conjunction with the disparities study that the bar did, that there might be an unconscious sort of reliance on an accumulation of complaints. And so as a result of that, the board basically directed our office to archive complaints older than 5 years. And so what that means is that the majority of our staff cannot actually see complaints that did not result in discipline or a warning letter or anything like that that are older than 5 years. So there are some folks in our office, I'm one of them, that can see those, but those folks who are evaluating complaints coming in at the intake stage certainly cannot see those older complaints to even be influenced in an unconscious way about it. So there's that. But I will say, on the other hand, in thinking about, sort of if someone is getting a volume of complaints, I think that is informative in a couple of ways. Could be one, it could be sort of what we're talking about in terms of, is there something more proactive that the bar should be doing in response to that? Even if they're meritless, it potentially suggests a problem with law practice management or communication issues that if we had some contact with the attorney might be remedied. The other thing is that the reality is that when there is an accumulation of complaints that don't result in discipline, it doesn't necessarily mean that there isn't something going on in the practice, but it's not terribly informative when you're looking at one complaint or two complaints in isolation. But then when you're seeing them over a period of time and they're similar types of complaints, it may mean that there is a pattern here that we should be looking at, because maybe there is in fact misconduct going on, but it's only more clear when you're seeing it in the bigger picture. So, I mean, there are important pieces to look at when you see that accumulation. But in any event, as I mentioned, the bar has determined that we don't want staff looking back at complaints that are over 5 years old. And so they're not, and those aren't being considered in terms of whether or not cases should be moved forward, and certainly are not determinative of future discipline.
Thank you, Ms. Lawrence. Ms. Paskey, you have your hand up.
Thank you, Ms. Buffington. Well, Melanie's comments just triggered memory in me. I think that a high percentage of state bar complaints are in fact related to law practice management issues. And when the compulsory MPRE requirements, MCLE requirements, continuing legal education requirements, were first adopted, there was a law practice management compulsory, and that was done away with years ago. And I'm not quite sure what the rationale was, but I think that we should reconsider making law practice management, continuing education, one of the compulsory subjects. I do strongly believe that there is beneficial impact when enclosing a complaint with something that does not rise to the level of a disciplinary offense. And in virtually every case where there is a disciplinary disposition, the respondent is required to go to state bar ethics school. And I know that staff is in the process of gathering statistics regarding recidivism rates for people who do attend and complete ethics school. But I think a lot of these complaints that are closed without action undoubtedly relate to practice management issues, and also probably a very high category within that is communication. So if we want to improve the profession, if we want to improve client satisfaction, I think we should look carefully at re-education in the areas of practice management, client relations, communication, and I think it implicates the trust account reportable action category as well, at least on the effectiveness subcommittee. When we received a presentation on that, the fact is that most of those reportable actions get closed because they are in fact related to practice management issues. And so I think there's a certain, connection or nexus between all these issues that could be addressed by restoring the law practice management compulsory continuing education requirement. Thank you.
Thank you, Ms. Pansky. Any other questions or comments? Okay, so Mr. Urick, so my understanding, So everyone has to agree if this is an area that we want to explore. Should we raise our hands, or if we agree or disagree, or?
Yeah, I'm basically asking if this is an area where we would like to, we could do it one of two ways. We've been creating working groups to kind of study this issue of a couple members and bring back those things to the full ad hoc commission, or if there's a specific directive that you have of staff, we can also just bring it back to the full ad hoc commission if you give us, what exactly, clear defined scope of what we need to bring back for decision making. So it's one of two ways on that. And so I'm just wondering if this is an area that the subcommittee would like to explore. Would we like to create a working group, or is there a specific question that you would like us to answer and bring back to the full ad hoc commission?
No one has their hand raised? I can make the decision for everyone.
Steve has his hand raised.
Okay, Mr. Wyatt.
Thank you. I having heard all of this, I don't know that there's a clear will to move forward with contacting respondents on complaints that we find don't have merit. But I wonder whether it would be important to go back to, I guess, the Office of Professional Competence to maybe take a look. I assume that's who it is, but I could be wrong. To take a look at why that law office management was removed from the MCLE, maybe evaluate whether it makes sense to bring it back. I don't know whether it makes sense to bring it back for only people who are in solo and small firms as opposed to a government practitioner or something like that. I'm also mindful that we don't necessarily want to put a whole bunch of additional requirements on people in solo and small firms, because then it will potentially impact them the most. Not only conceivably would they benefit from it, but they also, if they don't follow through, then we've set them up for another situation where they potentially run into an issue. So that looks like it's something that needs study, but I don't know that, for example, I feel well prepared to do that.
Thank you, Mr. Moat. Mr. Salik?
Yeah, so in my view, I think we could take this issue off our list of things to study. I don't really, for the reasons I mentioned earlier, I think there are downsides of starting to notify respondents of these complaints, which by definition are meritless, right? And I don't think we can dismiss the resource issue, so, from the board's perspective, resources are precious. And one of the things that I think the commission needs to do is to decide, whether resources are allocated in the best way possible. So to use the resources that will always be limited and for the foreseeable future are really inadequate to carry out this function, I just don't see deploying a lot of people power toward this problem. And I don't think it's a problem at all, actually. So, and I think we're going to create more mischief than good if we change this policy.
Thank you, Mr. Salik. So, Ms. Lawrence, just to kind of recap what you stated earlier, complaints that are closed for being meritless, that is not considered if there's a subsequent disciplinary action that's initiated. Is that correct?
Correct.
Thank you. Okay, Mr. Yurt, I guess we've checked something off of our list.
So I think that what I have direction on is that we're not going to create a working group, not going to go further with the notifying the complaining or the closed complaints for the attorneys when there's no discipline issued, but we can bring back something from the Office of Professional Competence, because I know Randy gave a presentation. There used to be like a law practice management course that was sunsetted for lack of use, I think, at the time, but I can bring an update at the full ad hoc commission on this law practice management issue and see why it was taken away. And then at that time, you can make a decision on whether to make a recommendation that it be reinstituted.
And I'm just trying to remember Ms. Pansky's comment. So the proposal to have the law practice management MCLE, did you, she said that will be on the, would that be on the MPRE, or is that something that we would offer to respondents that have a complaint initiated against them, or like what, when would this education take place?
I think she was saying to add it to the required MCLE, that there are certain topics, you know, diversion, other topics that ethics that are required. Or I'll let Ellen speak. She's here. Sorry, Ellen.
Okay.
Thank you so much. Well, I think I would amend my comment in light of what Mr. Slade pointed out, or somebody pointed out anyway. You know, it probably wouldn't be useful for government lawyers. So I think it should be studied further. But my point is that at various stages, whether it's made a compulsory MCLE requirement for lawyers who are in private practice or not compulsory, I think there would definitely be a benefit to enhancing a dedicated educational program to cover the practice management issues, and perhaps study whether the State Bar should institute a new third type of ethics school. Since we have general ethics school, trust account school, that might be a good fit. But anyway, I would like to see that researched and studied further.
Thank you, Ms. Pansky. Mr. Moet?
Thank you. I would just add that I do expect that law practice management, communication issues, things like that will be a major part of the self-assessment, the online self-assessment that the Office of Professional Competence will be rolling out over the next 18 months or so. So I don't know whether that necessarily constitutes a third type of class, but it certainly would provide valuable resources to people. So that may serve the same purpose.
Thank you.
Okay, I just wanted to add that after we finish all our informational presentations and we go through the summary of all the work that's been done to date and just getting clarity on next steps for each one of those topics. One of those topics is prevention. And so at that point, we'll decide if we want to form a working group on prevention. And I can see a lot of the issues being discussed right now being discussed in that type of working group, because they all kind of speak to prevention. Wanted to show that.
Good point. Thank you, Ms. Chavez. So I'm hearing from the group that we don't want to get any further information on impact of resources if this practice of informing respondents of closed complaints, we don't want any further information on that. Is that correct?
Madam Chair, if I could, I hesitate.
Yes.
I hesitate to come down so strong on this, only for the reason that, and it's escaping me, I don't remember what the specific comment or concern was from, I think, one of the members of this subcommittee about how this issue affects fairness. I mean, there's a reason why we're discussing it as a fairness committee, correct? And if it has to do with giving lawyers a heads up that there are folks out there who are concerned about their way they're practicing law and the way they're managing their, if it's a solo practitioner, that's valuable to a solo practitioner and could be, as I think Lisa's just mentioned, useful for prevention in the future. So I'm just trying to sort of weigh out, the risks and the benefits. I understand what Sean has referred to with respect to the disclosure requirements. I don't know whether that is something that could be addressed even by the State Bar if it's private. The private insurance industry is requiring disclosure of certain types of complaints, then I feel like maybe our hands are tied. But if there's an approach that the bar could take through a rule change or to request the legislature to take an approach, I feel like it merits some further look, quite frankly.
I agree with you, Mr. Duran. Any further question or comments? Ms. Chavez?
I was just going to say that's what a working group would do. is form a few people come together and direct staff on, and then we also, in partnership with you, identify what needs to be researched. Is there a difference between what solo practitioners have to share with their insurance versus people who work in companies, our law firms, et cetera? And that's where that type of deep study would take place. So therefore you really have all the information.
I just don't see the downside in getting more information, bringing it to the full ad hoc commission, and then letting the full ad hoc commission make the determination of whether or not it will propose making a change to the Board of Trustees. I just don't see a downside of doing that right now.
Madam Chair, if I could make a suggestion, then I think, and Mr. Ewart, I can't recall whether are we shooting for like 3 or 4 members of the subcommittees or the working groups rather, because it seems to me like somebody from OCTC, somebody from Respondents Counsel, and one other at least should be involved in this inquiry.
Yeah, we shoot for 3 so they can break ties on the subcommittee. It's a little bit easier, but I mean, I'll take whoever I can get with these working groups.
Okay.
Look at all those hands going up. Wow.
Well, yeah, so if I could get some volunteers to flesh this out, I think that we could, get this done. It won't be a ton of meetings if I think we can get the requests, and that striking the balance between maybe, we notify if they have more than 2 complaints, or some balance on resources versus cost and things of that nature. So do I have any volunteers? Steve, I see your hand.
I mean, I don't mind volunteering. Do you think I will be helpful? I'm not from OCTC and I'm not from any Respondents Counsel. I don't have affiliation with that. I'm just a government attorney at EDD, so.
I'll volunteer Ed Lear. I'm already on 3 working groups on this
Oh, wow.
subcommittee, so I volunteer Ed.
Sounds good.
Okay.
Okay.
If you don't mind the prospect of a tie, I'll be happy to be a resource person since
Okay.
I'm familiar with it. I'll be happy to be an ex officio non-voting member.
I will add you. Okay, we have our working group and we can move on. Thank you, everybody.
Hey.
Before you guys move on, just thank you so much for having me. This was good information for me. And if anyone in that working group has any questions or wants more information about our process, I'm available to continue the discussion. Thank you all.
Thank you, Ms. Garner. Justin, is next on our agenda impact of attorney fees and costs?
Yes,
Thank you. You will be presenting on that.
that is correct. So this is tying, wrapping up the discussion because this is our final subcommittee meeting. I've made a couple presentations on attorneys' fees and costs. If you could go to the next slide, Lisa. So the Business and Profession Code requires the state bar to recoup costs that are taxable costs recovered in civil proceedings. And those are kind of minimal, but the main one is the charges determined by the state bar to be reasonable costs of investigation, hearing, and review. And the licensee can be granted relief in some certain circumstances, but for the most part, if we go to the next slide, you'll see that the costs are very significant. And we've had talks about these costs in both fairness and effectiveness because they tend to be, as the further the case goes along, the more impact they have on the respondent attorney. And these costs are derived from a time study that was done in 2010 again, where they had OCTC and State Bar Court do certain tasks. And so they cost out all these tasks. And this is just for support staff. This isn't attorney's fees. This is all the support staff that goes into doing the trials. And so that's where they came up with this time study, and it's been tied to the inflation index. And so it increases by 2 or 3% every year, depending on the inflation index. But we did a survey of other states, and if you could go to the next slide. We also presented on sanctions. So we can't talk about discipline costs without sanctions. Sanctions were a statute that was adopted in 1994, but the rules for sanctions were only recently implemented in 2020. And so the sanctions only went into effect in 2021. But this is another cost that impacts the respondent attorney in addition to the discipline costs. So the sanctions are separate and in addition to the discipline cost. And so the next slide. We briefly surveyed other states, and 16 responded. 2 of them didn't do either fees or sanctions, and then most states recouped minimal costs, and most of the minimal costs were below $3,000 in total. So, and that was only of the states that were responded to. And so I'm bringing this back up because in some of those other discussions, there seemed to be interest from the committee on taking a look at these costs and seeing whether or not we want to form a working group or dive deeper into these costs to make adjustments on the sanctions or the discipline costs. The statute says reasonable cost, so that I think leads itself to a little bit of an interpretation. But I think this seems to be an area because the costs can be spread out over several years. We had that said to the subcommittee that the costs, they're due on an annual basis. So when you pay your attorney's fees, that's when these discipline costs are due, but there is often extensions for 3 or 5 years. We are trying to get the data on how often that is granted. The anecdotal evidence was that it's granted pretty frequently to the respondents, but it does have a significant impact on them. And so I'm kind of trying to close the loop with this and asking if this is an area where the subcommittee would like to focus and see if there's reevaluation of the discipline costs and sanctions. And Ms. Pansky has her hand up.
I would support a working group on this topic. The issue of costs is a very significant problem for respondents. There's a lot of concern about the amount. These are, it's a formulaic mandatory imposition of costs. It's not necessarily related to the expenditure of resources in any particular case. A lot of lawyers who find themselves in the discipline system have financial difficulty. The adoption of the new requirement of monetary sanctions is an additional adverse impact on respondents. Again, the majority of whom are not in large firms, they're not in government agencies, they can't afford defense counsel. So this topic has a lot of crossover issues. And if we're looking for ways to increase representation of respondents, that can't be divorced from the cost of defense and the fact that if the lawyer is disciplined at any level at a public approval or above, they will have mandatory cost assessment. So I would actually volunteer for a working group on this particular topic.
Thank you, Ms. Pansky. Mr. Larkin and then Judge McGill.
I just echo and support Ellen's comments. These seem, from a guy from the Midwest and most of the other states, to be significant, punitive, and I agree with Ellen that one has to put it into a picture of the entirety of the cost of defense, the repayment of costs to the bar, and also potential fines. And again, every state makes its own decision. You're an outlier right here, and that may be exactly where you want to be. In addition, even the cost of the mechanism of recouping costs in some cases are really difficult and cost a lot of staff time. I have no idea how you enforce it other than through your annual dues statement. And I don't know how many lawyers are precluded from practicing because they're unable to meet those ongoing costs even as extended. It just seems to me to be really difficult, and I'm confident it falls on the solos and smalls disproportionately, and probably has a racial disparity to it as well.
Thank you, Mr. Larkin. Judge McGill?
So in line with what Jerry and Ellen said, I can offer many anecdotal examples of attorneys who have told me and other judges that they're basically ending what they think are viable issues for them to defend on simply because facing the cost, particularly if you look at multi-day trials costs, which just balloon up. So to that extent, anecdotal evidence being what it is, we've seen this quite often, and I do believe also it does have an impact on attorneys being able to obtain representation. But I think the main one from at least our view as judges, where people really believe they're not pursuing defenses simply in order so they can afford to basically go back to practice at some point. So I would say yes, a working group, and I'd be happy to work on that if that's what you think is best, Sinead.
Thank you, Judge McGill. We have one volunteer thus far, Ms. Ewart.
I thought I heard Ellen too.
Oh, Ms. Pansky. Okay. That was quick. Do we need someone else?
If there is a volunteer, I'll take it. But if there's not, I can work with Judge McGill and Ms. Pansky.
Okay, and I don't want to overwork our folks. Can we ask members of the full ad hoc commission, members that may be on effectiveness subcommittee, if they want to possibly join some of our working groups, or are we just limited to folks?
No, we can reach out.
Okay.
To full ad hoc commission, because I think they created a couple working groups. We have some working groups, so there will be some email communication, and we'll work on recruiting, because this is where the bulk of the work is going to be done from here on out. So I'll work on that, soliciting further volunteers.
Thank you. Okay, I know we have a noon break scheduled for lunch. Are we advancing to attorney representation?
Yeah.
Okay.
Okay, everyone, good afternoon. So the purpose of this presentation is to give you some additional information that we have on attorney representation. Oops, excuse me. Is Erica Doherty with us? She's going to present on this, Justin. Oh, there she is. Can you, is she in the attending list?
Yes, sorry, I got I just need to promote her.
Okay, well,
she's been waiting. It's my fault for not promoting her right now.
Okay, so what we're going to do is share some information on State Bar Court appointed counsel. We actually have a panel and that Erica Doherty is going to share information on that. And then we're going to return to a little reminder of the State Bar's current work on this topic. I'm also going to share with you, so we're going to review all the potential reforms that Professor Robertson recommended. I'm going to give you an update on a few of those reforms that are ongoing. I'm going to share with you a new idea we have for an additional potential reform. And then again, we're just going to close this off with deciding if this group, looks at what we've done and is satisfied with the work that the State Bar is doing, and we're going to continue on, or do you want to form a working group in order to say, for example, suggest additional reforms? So we're going to start first with State Bar Court appointed counsel, and I'll give it to go ahead, Erica, introduce yourself.
Hi, thank you, Lisa, and good morning. My name is Erica Doherty. I am an attorney with the State Bar Court. I have been with the court for about 2 years, and in the past, I also worked in the Office of Professional Competence and in the Office of General Counsel. As Lisa mentioned, I was asked to provide some information about the use of appointed counsel within the State Bar Court. And appointed counsel is used in two case types. And these are two case types that are effectuated through the Business and Professions Code. So it's Business and Professions Code section 6007, and it's subdivisions B1 and B3. As you can see from these from the slide, these basically deal with attorneys who either lack mental competence or have substance abuse issues to a certain extent that are impacting their ability to practice law. The appointed counsel program has existed within the State Bar Court since before the current formation of the State Bar Court, which occurred in 1988. And our rules of procedure of the State Bar are actually the authority under which appointed counsel are appointed. Next slide, Lisa. So the State Bar Court maintains a panel of appointed counsel, and the State Bar Court has what are most akin to local rules of court, which are our State Bar Court rules of practice. And Rule 1106 of the rules of practice sets forth the minimum qualifications for the appointed counsel. To apply to the panel, it's all set forth within Rule 1106, but the applicant has to submit an application, a resume, writing sample, a letter of recommendation. They also have to demonstrate that they've been practicing law for at least 5 years and have some knowledge of the attorney discipline system. As part of the application, they have to themselves confirm that they have no pending disciplinary investigations, are not subject to disciplinary probation, and have no prior record of discipline in any state, territory, or court. The State Bar Court also verifies that they don't have any pending discipline within OCTC or any complaints that are currently being investigated that the attorney may not be aware of based on what was discussed earlier in the subcommittee meeting. And just a little bit more information, a attorney can be removed from the panel at the court's discretion, and then also a State Bar Court judge is not required to use a panelist. If for some reason we don't have a panelist who's available to take a case, they can look elsewhere to appoint counsel for these particular case types. And then one more thing is we do not require that the attorney maintain professional liability insurance, but we do ask them to let us know if they have it, and we ask for a copy of their policy if they do in fact have it. Next slide, Lisa. So the appointed counsel program rate. So the State Bar Court's Executive Committee recently increased the hourly rate for appointed counsel. That rate used to be $100 per hour, and it was recently increased effective May 5th to $300 per hour. That's a temporary rate, and it's in effect through the end of this year, and may or may not be continued at that higher rate. As far as the number of hours that attorneys are typically appointed for, so we have prima facie allowances for the number of hours that can be used for these cases. And if an attorney exceeds those prima facie allowances, we ask for them to provide justification about why the additional time was reasonable, and additional, all invoices as well as anything over those prima facie allowances is subject to approval by the State Bar Court, and particularly the judge who presided over the case. And next slide. Thank you. So the number of appointments each year varies widely. It basically depends upon how many of the 6007B1 or 6007B3 cases are filed. Last year, for example, in 2020, there were only 12 appointments that were made. And it's hard to predict what's going to happen from year to year. And that's pretty much it. If anyone has any questions, I'm happy to provide more information. And Judge McGill, I'm sure you could give more information if you'd like as well.
Thank you, Erica.
I don't see any hands up. Oh, there's Ellen.
Hands up.
I just wanted to mention that ADDC is working towards trying to put together a panel of lawyers who will be available to serve as appointed counsel. I anecdotally believe that it's sometimes difficult for the State Bar Court to find lawyers who are willing to serve. Although now that the hourly rate has been increased, I think it's probably become less difficult. There's one issue I just did want to mention, and that is, it's my understanding that one appointed counsel has subsequently been sued civilly for malpractice by the State Bar respondent who that lawyer volunteered to represent. And that's something that may be discouraging to lawyers who might otherwise be willing to serve. And I noted that in Ms. Dougherty's presentation, malpractice insurance is not required, but I think maybe the State Bar Court or somebody should look at that and also look at whether it's possible to arrange for insurance coverage for lawyers who volunteer to be appointed, because that's probably another issue that's of concern to potential volunteers.
Thank you, Ms. Spansky. Any further questions or comments? Okay. Seeing none.
All right, we'll continue on. Okay, so now I'm going to turn to the State Bar's work on attorney representation. You've seen me present on this before, but I'm just going to remind you that Professor Robertson, in his review of Professor Farkas's findings, recommended the following potential reforms. As I've shared, that he recommended that we develop a metric to track representation of attorneys, representation that's been completed, and we are doing that. He also recommended that we pilot test informing attorneys facing discipline of the importance of a securing counsel. Again, we're pilot testing that, and we're studying the impact of that as we speak. Skipping down to the bottom, he recommended that we create a discipline equity office to minimize disparities and support underrepresented attorneys. We did not prioritize that at this time due to lack of resources. So as you can see, these bottom two are still in the exploration mode, and I just want to give you an update on that one. So these are actually kind of tied together. It's the idea of working with ADDC to develop a roster of attorneys who agree to provide low cost and pro bono consultations. How do you identify the attorneys who are eligible for this? It would be working with the State Bar. That has to do with 3.4 right there on how do you identify income requirements. And we decided the easiest way to do that would be like attorneys who qualify for lower fees at the state that the State Bar has already determined this. They would be the ones who would be able to access this list of roster of attorneys who've agreed to provide pro bono consultations. So Professor Robertson's been working with the current president of ADDC, and they are, just like I said, really great feedback, as Ellen has said, that they're developing these conversations are moving forward. So I just wanted to give you that update, that we're really encouraged by this. Okay, so the next thing I want to share is that we also came up with our own potential reform, and that is, how about if the State Bar develops a pilot program where we develop our own kind of appointed counsel program for low-income attorneys facing discipline, similar to the panel that you just heard Erica Dory speak about within the State Bar court. And as she said, that program targets attorneys that met certain requirements. In this case, it would really be based only on income. And so we did an analysis and determined that around 5 to 6% of respondents that are facing discipline, that is those who had a case, an investigation or beyond, they pay reduced licensing fees. And right now the threshold for that is around $60,000. So if you show that you earn $60,000 or less, you pay reduced licensing fees. And so our analysis showed that in 2019, 264 respondents met that criteria. So we worked with ADDC to ask them to estimate the number of hours that are needed for representation for cases that are closed at various stages. and estimate that at the high end and the low end. And we did an analysis and we asked how much would such a program cost on an annual basis, given assuming 264 people needed a year and given the hours required for representation. And so here's the results of that analysis. And as you can see, most cases do close in the investigation stage. And ADC, that's the top row. ADC estimated that, you know, on the low end, they'll spend around 5 hours, but on the high end, it can take around 15 hours. And if you multiply that out, assuming $250 per hour, that's how much it would cost. Then each row is the different stages, and the total cost then for all if all 264 attorneys wanted representation, it could be as low as 500,000 and as high as nearly 2 million. And so the next steps in this work for us is to estimate the number of attorneys and costs using a higher income threshold. Professor Robertson once at one point met with CABLE, which I believe stands for California Attorney Association of Black Lawyers, and shared ideas and the income threshold of the 60,000, and they were concerned that that's too low, and could we explore, say, $75,000 and higher? So we'll be doing that work next. And then of course, it's the we have to explore funding options for this. So does anyone have any questions about this? So like about this program that I just described, and just any of the work that we're doing with attorney representation.
Mr. Larkin.
I just commend you for unwrapping this issue as well as you have, and encourage you to continue studying it. It is innovative. I don't know of this program being developed at this level with this sophistication anywhere else. And as I know, and others I think know, representation is a benefit not only to the lawyer represented, but to the entire system and to the public. So it's just, I think I encourage the good work you're doing. I'm interested in hearing where you land.
Thank you.
Any further questions or comments?
So Justin, you want to lead the group through the wrap up of this?
You're on mute.
I'm on mute. Of this attorney representation. So
confirm that the group either decides satisfied with the work the State Bar is doing, keep going, or form a working group to study this more. To me, at this point, I would say that the only thing a working group can do at this point is to offer additional ideas, which of course are welcome. But again, the other option is to look at the current portfolio, the work, the progress we've made, and just say, keep on going. And just so you know, we're always, we'll be giving updates to this commission throughout on this topic. Did I get that right, Justin?
Yeah,
that's where we're looking for the group what we're looking for from guidance from the group at this point.
You've seen what we're pursuing. We're, you know, that ADDC is working on their low bono representation. We're looking on the costs as potentially appointed counsel, and we can bring those costs back. But are there other areas where the subcommittee would like to focus in terms of attorney representation? Or is this an area that you think would need a working group, or is what we've talked about on the action plan so far is to bring this information back just sufficient to bring it back to the full ad hoc commission?
So you're asking if we want more information to be brought to the full ad hoc commission, or do we want to form a working group? Is that correct?
Yeah, right. Is there a necessity to form a working group, or is, you know, the appointed counsel costing out that sufficient that we have enough direction, staff can just bring that back to the full ad hoc commission? Or are there other areas that the subcommittee wanted to explore with the attorney representation that would require a working group to be developed? That's what I'm looking for. Are we okay with the path that we're on? and there's not a need for another working group. And we'll bring back the appointed counsel information at the 75,000 threshold to the full ad hoc commission, and updates on the low bonal that Ms. Pansky referenced to the full commission.
I don't see any hands raised. Oh, Leah's joined us.
I see
Hi,
Ms.
Leah.
I was listening in previously, but I just joined by video.
Thank you. Good to see you.
Ms. Good has her hand raised.
Oh,
Madam Chairperson, I think what's been done is really fantastic, and I don't personally see a need for a working group. I think we can have too many working groups, and those should really focus on things where that would be beneficial. So my vote would be no.
thank you, Ms. Good. I second your opinion on that. Any further question, comments? Okay, seeing none. It's 11:27. Ms. Yurt, I think Ms. Chavez, are you done with your
Yes.
presentation?
Yes.
Thank you. Mr. Yurt, should we wrap up, or should we try to drag this out for 30 minutes and then take a 30-minute lunch break and then double back? I mean, I don't.
It's up to you. We can either take lunch break now and then bring because the second part of the agenda is just the wrapping up all the different discussion topics. So if it makes sense to break now and come back at noon, or if you want to, I can start now. It doesn't have to be continuous because they're individual topics. So I could start on the wrapping up if that's what the subcommittee prefers, whatever anyone prefers.
And we anticipate the wrap up to take approximately how long? Maybe
An
30
hour or
minutes,
so.
about an hour.
30 minutes to an hour. It all depends on the discussion.
I don't know. It's up to the group. Should we try to plow through it for 30 minutes and then take a noon break, or should we take a break now and then reconvene at noon? I don't want to rush us, but I don't want to waste time. But if we all need a break, I mean, we started about an hour and a half ago.
Madam Chair, I'd suggest trying to start the wrap up now and seeing how far we get in half an hour. If we finish, then great, we can finish, and then, but if not, we can come back after a quick lunch.
Sounds good to me, Mr. Ryan. All right.
Okay. So I will begin the wrap up of all the different topics that we've discussed. All right, so the next slide. So the first topic I wanted to discuss, just to bring closure to, is the study on racial disparities and the attorney discipline system. We presented to the subcommittee the Farkas report. Professor Robinson came to a meeting and he talked about his different policy recommendations. I bring this up because we're trying to bring up all the topics that were discussed at the meeting. This one really is the genesis for a lot of the working groups and a lot of the work that we've done. So the next steps could be almost every working group that was created from here, but it's just reminding the subcommittee that we reviewed the Farkas report, we reviewed Professor Robertson's options, we took actions on some of things to explore further, and other things we took a wait and see approach. But I just wanted to remind about this action that we've taken so far. So if we could go to the next slide. The next slide is RA Bank Matters. And so we wanted to review the RA Bank Matter process. This was part of Professor Robertson's recommendations. OCTC presented on RA Bank Matters. We had Randy DeFentorum from the Office of Professional Competence that talked about the commingling of funds and why and whether or not it was appropriate to have a base amount in the client trust account, because the impact on those attorneys that don't have as large of client trust accounts, and so they get these have to deal with these RA Bank Matters more. And we reviewed the recommendations from Professor Robinson. There was discussion on addressing the de minimis standard. No action was taken on that, and with regard to the action taken, the revision of the bank letters to the respondents, that the subcommittee kind of talked about taking a wait and see approach to see how that impacted some of this. So there was no working group created for this. There was no action that was taken as a response of this matter. And this is where I'm just opening up to the subcommittee, if that still is the case, if everybody's comfortable with where we're at with RA bank matters, and there doesn't need to be a need for further exploration. And I'm hearing nothing from the subcommittee. So I think I will take that silence as they're comfortable with the direction that we're headed on this issue, and we will continue on this issue. If we could go to the next slide. So case expungement. We reviewed what the state bar does with expungement, and then also with the discipline that is on the website. We had the administrative expungement. There are two types of administrative expungement that we reviewed, and the presentation was given to the subcommittee. We had presentation on criminal expungement. So Ray gave us a good presentation on what that criminal context for expungement is and how it differs from what we at the state bar do. And we had a couple of discussions on what is displayed on the website, what is on the attorney profile page versus what is on the state bar court website, the red versus the blue site. We also talked about consumer alerts. And as a result of those discussions, we formed a working group on expungement. And that working group on expungement has met once. We went over a lot of the details on what data would be requested to kind of make changes. I have a research project to look at all the other states and how long they keep everything on their website. Our Office of General Counsel, I think it was attached to a previous agenda item here, provided a memo on what other states do and what the state bar does in terms of disclosing discipline. And the expungement working group has asked me to update that because it's about 5 years old on what those other states currently do for the length of time that the discipline stays on the attorney profile page. So we will continue work. I anticipate the expungement working group meeting again in late September, early October. We should have the research done and provide them the information so they can potentially bring recommendations back to the full ad hoc commission. This, I don't necessarily, we've already created a working group, so this is just informational so everybody knows where we're at and what we've been doing on this topic. If we can go to the next slide. Progressive discipline. And so this is where this topic was kind of touched on earlier today when we talked about closed complaints and progressive discipline. This topic, we had a presentation from OCTC on the progressive discipline. And then we also had, this topic came up in terms of effectiveness on judicial discretion and whether or not the judges have enough discretion in considering prior discipline and whether or not that impacts settlement. And so this topic overlaps both the fairness subcommittee and the effectiveness subcommittee. And this is an area where I think that we need a working group, or if the subcommittee determines we need a working group of the full ad hoc commission. So I think that this is, since it does, there is interest on the effectiveness side, and there has been interest when we presented these on the fairness side, that we should make a working group of all the members of the ad hoc commission, potentially soliciting that at our September 17th meeting, and look at prior discipline and see whether or not it is being used appropriately, or if there could be changes made to make it more effective or fair. So I'm just looking for blessing from the subcommittee here that that should be the direction that we head. Okay, I see heads nodding, so I will take that. Okay, so we're whipping through these topics. The next topic is the perception of state bar independence. This was, just to review the factors that impact the perception of state bar court independence. And we had a presentation from state bar court and gave various examples that can impact the perceived perception of independence. There was certain things that were talked about in terms of, whether or not they use certain Office of General Counsel resources. and the State Bar Seal and other things. Some of this was delegated to the Bench Bar Committee.
Justin,
yeah.
just to clarify, it's not the Bench Bar Committee.
Oh.
It's a committee that doesn't really have a title, but it is the board leadership and the court leadership. We just met yesterday.
I apologize. So you met yet? Do you want to provide an update
Yes.
on what you met about?
Yes.
Well, Judge McGill is on the line, so to speak. Judge McGill prepared a memo on this topic. We unfortunately spent most of our time on another topic, but we did touch upon State Bar Court independence issues briefly at the conclusion of our meeting, and we will be following up on it. And there's sort of 3 specific asks or needs that the judges have identified, and I am confident that we'll be able to address at least the majority of those needs working through this process.
I agree with what Leah says. I think we're making good progress.
Okay.
Okay. Thank you.
So it sounds like we don't, progress is being made, that there doesn't need to be a working group to address that issue. And
Sorry, I just want to capture this, Leah, delegated to. I just want to.
I can maybe share that with you offline, Lisa. It doesn't actually have a name.
Okay. Okay, delegated. That captures it. Okay.
Oh, okay. Thank you.
Mm-hmm.
And so if we can go to the next slide, then this is where we talked about this issue just a couple of minutes ago, how we handled the closed complaints with no discipline. There was a thorough discussion. We presented on the current policy, and we formed a working group to study this issue. So I don't need, when I originally was doing this slide, I needed further direction, but I've received direction, and we will progress on this issue. So I don't need to spend a lot of time on this. We can go to the next slide, Lisa. This is another one. I thought I was going to have lunch. So the next steps, the TBD, is we formed a working group. We have a 2-person working group where we will evaluate the costs of the discipline system. That includes the discipline costs and sanctions. We'll evaluate what other states are doing and come back with potential recommendations on those procedures. If we go to the next slide, we had this presentation earlier today as well. The communication with the complaining witness during intake. Kelly Gardner provided us with the current process. There was a little bit of discussion, but there was no direction to take it anywhere from that. So I think that the information gathering, the presentation to the subcommittee seems sufficient. So I didn't hear any need for any further follow-up, and I'm just confirming that now, that I think we are good. Steve has his hand raised.
Mr. Maude?
Thank you. It's not a comment directly on this point, but Ms. Pansky did raise earlier the topic of the MCLE, and I don't know whether that was captured separately. The MCLE on law practice management.
Right. I have that in my notes to follow up on, and so I will. And so if we can go to the next slide. And this is another, I think this might be our last slide. Respondent representation, we decided that we were comfortable, or the subcommittee was comfortable with the actions that had been taken to this point, and that further updates on the progress of the low bono panels and also the research on the court-appointed counsel would be brought back to the full ad hoc commission, and that a working group wasn't necessary at this time. So that's the summary of all of the action that this subcommittee has done to this point. I don't know if there are any questions or comments or anything.
No questions, no comments? Did we capture everything?
Yes, I mean, we talked about everything, so that went much quicker than I thought because we covered everything and there's not much discussion, so.
Okay, well, it's 11:41. So we've covered everything on our agenda.
We have.
Okay, and the full ad hoc commission will meet on September the 17th. Is that correct?
Correct, at 9 o'clock. And at that time, this subcommittee will be presenting all the actions that we've taken and progress on the working groups that have met prior to that. And then effectiveness will be doing the same. And then we'll go on next steps for the full commission.
Sounds good. Okay, well, I don't want to waste, well, not waste, but I don't want to take up any more of your time. I just want to thank everyone for your participation, your input, and your insight into these very, very important matters that affect our discipline system. Any questions, comments? Well, thank you all. I wish I had more to say. I didn't have anything written out. Just thank you. Have a nice rest of the day. Have a nice lunch. See you soon on September the 17th.
Thank you. Thanks.
That's it.
Thank you.
Okay. Thank you. Have a good day.